mandamus. The term mandamus means we command. This writ is employed by the court to direct a public official who has failed or refused to do his duty to resume his work. The writ of mandamus is also issued against a public body, an inferior court, a corporation, a tribunal, or a government. Next, we move on to that. The next writ is quaranto. The term quaranto means by what authority or warrant. The Supreme Court or High Courts employ this writ to avoid illegal usurpation of a public office by an individual. The writ of quaranto authorizes the court to examine the legality of a person's claim to a public office. Now, let us see the overview of the important landmark cases relating to fundamental rights. A.K. Gopalan vs. State of Madras, 1950. In this case, A.K. Gopalan filed a petition under Article 32, thereby invoking the writ of habeas corpus against this detention. Later, he was prohibited from disclosing the grounds based on which he was detained, since Section 14 of the Preventive Detention Act 1950 prohibited such disclosure in the court. As a result, he claimed that such detention violates Article 14, 19 and 21 of the Constitution, and further the provisions of the Act violate Article 22 of the Constitution. This case led to the landmark judgment of the Supreme Court of India, wherein the Honorable Court held that Article 21 of the Constitution shall not require the Indian courts to apply the due process of the standard of law. Further, the Honorable Court upheld the validity of the Preventive Detention Act 1950 except for Section 14, which provided that the reasons for detention given to the detainee or any representation made by him against such reasons shall not be disclosed in a court. Another case is Sankari Prasad vs. Union of India, 1952. In this case, the constitutional validity of the First Amendment of 1951, which curtailed the right to property, was challenged. In this case, it was challenged that the amendments that curb the fundamental right of the citizens are not allowed by Article 13. Regarding Article 31A and 31B, it was held by the Supreme Court that the power to amend the Constitution under the Article 368 also includes the power to amend the fundamental rights. Another case, Golaknath vs. State of Punjab, 1967. In this case, Golaknath and his family claimed an excess of 500 sections of land in Punjab. Meanwhile, the state government made an enactment, namely Punjab Securities and Land Tenures Act 1950, by virtue of which Golaknath and his family were only allowed to keep an excess of 30 sections of land and not more than that. As a result, Golaknath filed a writ petition under Article 32 of the Indian Constitution, questioning the legitimacy of the enactment and further stating that his fundamental right to property was being violated. The question before the Supreme Court was whether the Parliament had the ability to revise the fundamental rights mentioned under Part 3 of the Constitution or not. The court ruled that Parliament does not have the power to curtail any of the fundamental rights in the Constitution. Next case, the Kesavananda Bharati vs. State of Kerala, 1973. In this case, the aforementioned Golaknath case was reviewed. It was held by the court that basic structure of the Constitution cannot be amended. The Supreme Court, through its 766 judgment, had ruled that the Parliament has no powers or the authority to alter the basic structure of the Constitution. Indira Gandhi vs. Raj Narayan case, 1975. This case dealt with election disputes involving then Prime Minister Indira Gandhi along with the purpose of the 39th Amendment of the Constitution. The primary question involved in the case was of the validity of the Clause 4 of the 39th Constitution Amendment Act 1975. The Supreme Court in this case added certain features as basic features to the already existing list of basic features laid down the Kesavananda Bharati case. such as the rule of law, democracy, and judicial review. Another important case is Maneka Gandhi vs. Union of India, 1978. In this case, Maneka Gandhi's passport was impounded in public interest. The government refused to provide any details in the interest of the general public. When the reasons for impounding her passport were asked, as a result, Maneka Gandhi filed a writ petition under Article 32, stating that the action of the government violated Articles 14, 19 and 21 of the Constitution. The government responded by stating that her passport was impounded because her presence was likely to be required regarding certain legal proceedings before a commission of inquiry. The Supreme Court held that a procedure under Article 21 of the Constitution must be free from arbitrary, unfair, oppressive or unreasonable aspects. And another important case is Minerva Mills Limited versus Union of India, 1980. In this case, the Supreme Court provided certain clarifications on the interpretation of the basic structure of doctrine. The court held that the power of the Parliament is limited in amending the Constitution. Therefore, the Parliament cannot exercise such limited power to grant itself an unlimited authority of amending the Constitution. Thus, the Parliament cannot take away the fundamental rights of individuals. The judgment in this case also struck down Clause 4 and 5 of the 42nd Amendment Act 1976, enacted during the emergency imposed by Prime Minister Indira Gandhi. Now we have come to the conclude part of the session. Fundamental rights enshrined in the Indian Constitution are like a guarantee, which means as long as they exist in the Indian Constitution, democracy will prevail and all Indian citizens can be assured of the protection of their basic rights. Such civil liberties prevail over any other law of the land. Fundamental rights are essential for the comprehensive progress of the people and the nation. Thank you.